The Labour Court has dismissed with costs an urgent application by suspended Public Enterprises Director General Kgathatso Tlhakudi. Now, on Wednesday, Judge André van Niekerk said Tlhakudi had not sought to protect his right with the urgency warranted in the circumstances. Tlhakudi was accused of overruling a panel's recommendations in the appointment of a security manager within the department instead of installing a candidate of his choice. Let's get more now on the issues surrounding the suspended Director General. And we speak to Mr. Tlhakudi's lawyer, Adv McGregory Kufa. Advocate, good morning to you and thank you very much for your time. For the benefit of those who have not been following this case, are you able to flesh out just a bit more detail as to why your client was suspended as the Director General of Public Enterprises?
Okay. Good morning, Paul, and good morning to all viewers. I just want to give just a brief synopsis of what the case is really about, not what people are made to believe what the case is about. The case against Mr. Tlhakudi is about the fact that he has been at the forefront of making protected disclosures to the President, who is the first citizen of the country, Mr. Cyril Ramaphosa, pertaining to the sale of the South African Airways, which deal is linked with the Kgathatso consortium, which the Director General believes there's been some underhand dealing in the manner in which the Minister for Public Enterprises, Mr. Pravin Jamnadas-Gordhan, has sought to arrive at the sale of the South African Airways. But be that as it may, they since suspended him for charges relating to misconduct, which is a sort of an intimidation so that he doesn't really let the cat out of the bag, so as to say, on the issues of the sale of the South African Airways. But be that as it may, the case that he had brought at the Labour Court was to challenge this suspension, which in terms of public service regulations, a suspension can only ordinarily run up to 60 calendar days. Once those 60 calendar days have expired, an employee should automatically be taken back to work. In other words, the suspension becomes obsolete by operation of law, what we term at law ex lege. So it becomes automatically expired. So Mr. Tlhakudi had sought to vindicate his rights by bringing an unlawfulness application before the Labour Court, which is correctly so because he's trying to vindicate his rights in terms of Section 10 of the Constitution, which is his right to dignity. In other words, when an employee is suspended, most people think that because that person is suspended with pay, there's no other prejudice that person is suffering. And we are saying that is not the correct contention. A person suffers further prejudice to his dignity. There's a lot of anxiety. There's the stench and stigma of being suspended that even if when you go back to work, people will still be thinking you did the things that you are accused of having done so. So that's one of the issues that we addressed pertinently in the papers at the Labour Court. And the second issue was the right to practice a trade or profession in terms of Section 22 of the Constitution, that any person who is a citizen is entitled and enjoined to enjoy his rights to practice a profession. And by him being placed on that mandatory suspension, which has become unlawful, which the lawyers of the President and the ministers have also conceded that indeed the suspension is expired, are still insisting that he should not return to work, so which is unconstitutional and inimical to the values of our Constitution, which are enshrined in Section 1C and 2 of the Constitution.
You've said a mouthful, Advocate Kufa. I just want to pick up on one element, and that is absolutely confusing for me, and that is that you are saying your client gets suspended after he made protected disclosures to the President about the sale of SAA. Why would the President take sides instead of listening and perhaps understanding the information that is being given to him instead of taking such a drastic measure? I'm trying to understand why the President would act in this way, which clearly prejudices your client.
Yes, indeed, Paul. The manner in which the first citizen has acted is not acted with the highest degree of probity for the first citizen. Because he is, if anything, as the first citizen, is the first person to be accountable to the Constitution. So he's supposed to have protected the rights of the Director General and also the rights of the South African public, their interests at heart. Because remember, the sale of the South African Airways involves the rights of the South African citizens, which is a public interest right. So that's why Mr. Tlhakudi had brought this application, also premised on public interest rights, to say let's protect the rights of the public, the general old lady in Manamlele or the one who's sitting in Kurumani. They deserve to know what is happening to the South African Airways. They deserve to know what is happening with their government. Sadly, the president has not upheld the Constitution as he ought to do. That's why the application has been brought. But unfortunately, the learned judge took a dim view of the application and was more scatological on Mr. Tlhakudi's language in the application, which we deem not appropriate to answer at this moment, because this matter is substitute, because we intend to bring an application for direct access to the Constitutional Court to still challenge that judgment, because you can't say in a judgment that where it is quite clear that the suspension is now unlawful, but you then still go on to dismiss the applicant's application saying he's got an alternative right. There's never an alternative remedy for an unlawful decision.
All right. So for the viewer who's now possibly listening with an even more keen ear here, I want to go to the article, just one of the articles that have been written in the City Press around this suspension. And there's a section there around the sale of SAA, because this is where this case seems to be anchored on. There's a portion where it says in the paper, Mr. Tlhakudi alleged that the transaction had been a template of how the rest of the SOEs would be disposed of to the detriment of the South African citizens who are the ultimate shareholders and the shareholders of these assets. Tlhakudi said what was unfolding was how renowned political analyst Noam Chomsky had first characterized the privatization technique, and that is, I quote, defund, make sure things don't work, people get angry, and then you hand it over to private capital. Is that the contention here by your client, that the sale of SAA has essentially become a template for how the rest of the SOEs are going to be disposed of and disposed of to private capital?
Yes, indeed, the manner in which, if you can see, there's I wouldn't want to make it as a factual disposition, but if you look with your own keen eye, as you can see how the SOEs are being run, you can look at yourself. Denel is now in a shambolic state of affairs. If you look also at the manner in which Eskom is being run, if you look at also this Transnet, I've heard calls on news this morning that Transnet must be unbundled and sold privately. So you can see that there's a systemic distraction of SOEs so that they can be literally handed over for privatization. There is that systematic. It can be seen with the eye of even an ordinary citizen.
Wow. Well, if these are the contentions of a man who essentially is the CEO of the department, it raises a whole manner of political questions, because the president, if what you are alleging is indeed his action after being taken into confidence, because was this the manner in which the DG sought to act, and that is to say to the president, I'm coming to you in confidence, and instead the president acts contrary to what the DG thought? Is that part of what angers the DG, if I could use that word?
The DG is not angry. The DG is exercising his legitimate constitutional and labor law rights. He's not angry. He's not at all. That's not. there's not even a fathom of anger in him. He's just exercising his rights. Because if you not, he also approached the Minister for Correctional Services, to whom powers has been delegated to discipline him, to say, let's not the government waste a lot of money and resources in this disciplinary inquiry by having it run under the auspices of an internal inquiry. Because remember, if it's the auspices of an internal inquiry, right now, if you look at it, there are two SEALs, one is an initiator and one is the chairperson. These guys' fees don't come at no less than 75,000 rand per day. Now, if this matter was to be transferred and be held as a Section 188A in terms of the Labour Relations Act, like that is an inquiry by an arbitrator, it will only cost the government nothing more less than 3,000 rand, even if the duration of that disciplinary inquiry is to last for 60 days or 80 days. The only cost that the government would have paid for that inquiry by an arbitrator is only 3,000 rand. So compare 3,000 rand and compare the 75 times, I don't know how many more further sittings this matter is likely to endure.
Advocate Faku, there's a clear political question. I know that you are a legal man, but let's try and ask you this question. The President has been on record, so has his Minister of Public Enterprises, that the SOEs are not being disposed of or are not being privatized. You speak about ESCOM, and so is SAA. Is the DG of the firm view that these SOEs are being or are on their way to being privatized? That's the simple question I think I would like to get clarity on. Is that what he asserts in his court papers?
Probably I'll answer your question with a rhetoric question. In other words, what the Minister for Public Enterprises has been saying in public and what is happening behind the doors are two different set of scenarios. If you look at Denel has not been able to give salaries to its employees for the past 18 months. So if you're not wanting an SOE to be on the verge or to collapse, why would you not fund that SOE, which is in a debilitating financial condition? Same also is applying to a number of other SOEs like Safcor, you name them. They're suffering from the same fate. So what the minister and the president are saying is literally tongue-in-cheek. That's all I can say.
My goodness. There's another crucial element, Advocate, that I would like to converse with you. And again, it stems from this article where it says that Tlhakudi is of the view that the decision to sell the airline had been intended to benefit a few privileged individuals, handpicked by the minister in an irregular and unlawful manner. And then he talks about a particular meeting where a junior to Tlhakudi would have been sent to be part of this meeting, completely sidelining the DG. Is that indeed a fact? Is that what is contained in the court papers?
Yes, indeed. There are even replete WhatsApp exchanges between the friends of the minister, making exchanges with Mr. Tlhakudi, and Mr. Tlhakudi being told by the minister that these people, you must assist them. He just uses the word assist. Obviously, he wouldn't say give them what they want. He just says assist them. But now these people, they come also picking on the name of the minister to buttress their way into the Department of Public Enterprises. And then you have juniors who are assigned to Tlhakudi now acting over Tlhakudi in very critical matters like the unbundling of SAA and the unbundling of other critical SOEs.
Sure. Well, that's quite a mouthful you've told us there. All right, so let's come back to what is happening now, Advocate Kufa. So your client losing out at the Labour Court in trying to overturn this decision to be placed on suspension. What's his next move?
Well, his next move is to approach the Constitutional Court to seek direct access, because the judge who presided over this matter is overruled his own matters, which came 2 months ago, where he ruled that suspensions are unlawful and that an applicant is at liberty to bring an application for unlawfulness. And sadly, he's had a second mind, but this second mind should have been judiciously exercised and also explained in the judgment, which the learned judge failed to do. So, which is a very crucial issue which the Court will need to decide upon, and also the public interest that the DG remains on suspension, not for suspension for labor issues, but for other issues like protecting or trying to shy away to the so that's the first citizen, and the ministers are trying to blindside him for the shenanigans that are happening pertaining to the sale of SAA.
All right. Look, I'm going to try and squeeze in this last question. I'm completely out of time, but I think it's only logical that if the assertions that are being made by the DG are as damaging as what you are telling us here, it's only logical that one asks the question, the relationship between the two, there is that famous saying that it's broken down irretrievably. If the DG were to win at the Constitutional Court where you intend going, does he think that he can still have a working relationship with Minister Gordhan?
Unfortunately, I'll refrain to comment on that because there's still a disciplinary inquiry which is underway against the DG. But suffice to say that the issues that the DG raised in his court papers, Minister Gordhan did not answer them at all. He refrained from answering them, particularly the SAA cell. He did not answer them at all. And then there is also if you look at the trend pertaining to Director Generals throughout the countries, that if a Director General is suspended, the Minister will survive the brand, but not the Director General. We've had the case of Director General planning a few years back ago. It's him who faced the brand despite winning at court. So the issue is that, unfortunately, once there's a fallout between the DG and the Minister, even if the Minister is wrong, the DG always placates and takes the fall.
All right, and I take it that you're going to respond in exactly the same fashion. If I were to suggest to you that, would he be anticipating a payout then, in which case he would say there's been a breach of my contract?
At this current stage, there's nothing has been put on the table about whether there's a payout or anything. Nothing has been tabulated to the Director General. So there's nothing to talk about on the issue of payment.
All right. Let me thank you very much for your time and just how candid this interview turned out to be. I really didn't expect the kind of information that you have given to us. Hopefully the department is listening, and let's hope they're going to accept the right of reply that I am offering to them at this point in time. Hopefully they will be available. That's Advocate McGregory Kufa, and he is the lawyer for suspended Department of Public Enterprises Director General Kgathatso Tlhakudi.